Hmm. Hmm. Hmm.
Yes. No, I can do it. Do it. Just I was speaking to her. I thought you were. You touch me with it. Touch me. Okay. I was just giving her some tips. How you have to prepare. Am I audible?
Yes, sir.
Yeah. Good morning, Dr. Bharat.
Good morning, sir. Good morning.
How do you do? Once again, thank you very much
Fine. Thank you, sir.
for associating with our college in this webinar. It's really
Yes, sir.
very kind of you that we could able to take the topic into the academicians.
Yes, sir. Thank you, sir. Participants seems to be less. You have not shared the link to your students?
No, we have shared. We have shared. I think the students are joining in the room.
Okay,
I think
okay. No problem. No problem.
they are
But I have,
joining in.
yeah, I have given feedback link on coordinator's mobile number. Please circulate
Yeah.
to all so that they will get the certificate. Okay.
Yes, yes, yes.
Sir, I have done it, sir. I have done
Okay. Okay. Thank you, ma'am. Thank you.
it.
Because otherwise they will tell you that we are not got coordinator is the responsible. So ultimately tell them to fill the link so that everyone will get the.
मैम रिसेप्ट कर सुनो
ಮೇಡಮ್ ಸೌಂಡ್ ಬರ್ತಾ ಇಲ್ಲಲ್ಲ
I think, madam, we can begin. It's 12,
Sir,
12:40.
yes, sir.
Shall we wait? Okay.
Sir, I was waiting for students to join till 50.
Yeah, yeah.
50
They are
participants.
joining now. They are joining.
Okay.
Seems the
Pratima?
class is over for them.
Yeah, yes. Pratima, are you there? Pratima?
Pratima was there actually. She met me just now. Where is Pratima? I have to make her. Is she host? No?
Sir, you make her host, sir.
No, I am a co-host now. I think I have to. Where is Pratima? If Pratima is there, I can host.
1 minute, sir. I'll tell her to join.
Whether Pratima has joined from college, I don't know. I think. I think she has joined from college. This one, college ID only. Yes, Pratima is there now, I think.
Yes, sir, I'm here.
Yes, Pratima, you can begin, Pratima.
Okay, sir. Good afternoon, everyone present here. Today, on behalf of NIPAM and B.V.Bellad Law College, I welcome you all to the online awareness program on intellectual property rights and patents and design filing. I welcome with respect our today's speaker, Dr. Bharat N. Suryavanshi, sir, who is Assistant Controller of Patents and Designs. Sir is working for more than 18 years in central government under the Patent Office, Ministry of Commerce and Industry. He has done MPhil from Gulbarga University and his PhD on topic bioefficacy and photochemical studies on medicinal plants of Kinwar and Mahur Forest of Nanded district. Sir has published various national and international papers and has also delivered many lectures on IPR. He was deputed for training at Tokyo in Japan on examination and IPR issues. He has given landmark decision by rejecting Pfizer patent application.
Pratima, your voice is not coming. Check.
Maybe net problem, sir.
Yeah, I think she is. So I take over.
Okay.
Yes, sir.
So I welcome you all to this webinar on the topic, the awareness on intellectual property rights filing of designs and patents. We have amidst of us Dr. Bharat Suryavanshi, the Assistant Controller for Patents, who will be taking us through to this workshop, to this awareness program. And we're happy that this program we have been associated with Rajiv Gandhi National Institute of Intellectual Property Rights and Management. And they are very kind enough to join with our institution and conduct these programs very often. So I hope that this awareness program will bring a lot of enlightenment to all the participants who are participating from various parts of this country. We have some of our friends from my neighboring state, Andhra Pradesh, and we have the students of the law colleges and also the academicians from various law colleges attending to this webinar. And I hope that in the end, all the queries that we have with respect to the filing of patents and designing, they all will be cleared by the scholarly speech by Dr. Bharat Suryavanshi. Sir, Dr. Bharat Suryavanshi, I welcome you on behalf of K.L.E Society's B.V.Bellad Law College and on behalf of all the participants here. And I request you to kindly take over. And before that, I request each of the participants to kindly mute from your side so that we can listen to Bharat Suryavanshi without any disturbance and smoothly. Over to you, Dr. Bharat, please.
Thank you, sir. Thanks for introducing me. I also welcome you on behalf of Rajiv Gandhi, National Institute of Intellectual Property Management, Nagpur, Government of India. As you are belongs to law, many are for knowing what is IPR, even though just I'll throw some lights on the IPR. Sir, I cannot share my screen. Please allow me to share the screen. Host disabled attendee
Okay, sir.
screen.
Okay, sir. Yeah, sir. Sir, just a second, sir. I'll do it.
You do. Have you done? Yes.
Sir, you can share.
Yes. Are you able to see my screen? Anyone, please? Ma'am,
Yes, sir.
Yes.
slides are
Yes, sir.
moving?
Yes, sir. We can
Okay.
see.
Yeah. First of all, I introduce where I'm working. I work under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade. Our office is called as Office of the Control General of Patents, Designs, Trademark, and Geographical Indications. As you might have knowing, we are having different patent and design offices at Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS that is called Patent Information System. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management located at Nagpur. We are having trademark offices in addition to four. One is at Ahmedabad, Gujarat. We are having geographical indication office at Chennai. This is the pictorial view of our offices Mumbai, Delhi, and Chennai and Kolkata. This is our training center wherein we are giving trainings to all the IP officials, professor, students, company managers, scientists. Many of the students who are coming here to know about the IPR, even foreigners during the WIPO program, BRICS programs, they come here to know about the Indian Patent Act. We conduct all classroom trainings to everyone. This is our website. If you are not knowing anything about the intellectual property, please log on to www.ipindia.gov.in. You will get all details about the patents, designs, trademark, and geographical indications. This is an awareness program. I cannot go in detail in each IP. If I want to take only patent, it takes years together. If I take design, it takes year together. To be in perfect, we are keeping many more programs every month. So we are keeping updates on our website as well as on social media account like Facebook and Twitter. Make a note of that and see whenever you want to join the programs, join and take the benefit of that to be an perfect in the IPR. Let us see today's topic. What is intellectual property? As I have indicated in my slides, something blooming in the mind. It means product of mind. How it arises? During discussion in the classroom or in the lab, or you're thinking on some problems in public or alone, giving solution to those kind of problem. Therefore, intellectual property is a property that arises from human intellect. It's a product of human creation because human is an intelligent animal in the animal kingdom. He is having power of thinking, so he is ready. He's always in research for solving new challenges and new problems in the world or in and around him. For example, we are facing a lot of problem in the fields of technology in case of new designs. So somebody develops new process for production of biodiesel, means something new technology, or somebody develops a device or a machine that convert solar energy into electrical energy, or somebody develops herbal medicine for cancer because we are not having herbal medicine for cancer, or, or if you are developing new technology which can convert your wind energy into electrical energy. So something if you are doing new, that's an intellectual property. That may be in the form of product, process, design, books, that is on copyright, mark like trademark. So something if it's originated from mind is called intellectual property. In the December 2019, we heard about the coronavirus. At that time, we are not having any treatment method or vaccine for that coronavirus. So our scientists all over the world started to carry out the research. And in the middle of 2020, we got Covaxin, Covishield. What is this? This is an intellectual property which arises from the human mind. So any problem comes, we are here to solve that problem. So intellectual property, we can directly say product of mind. Let us see what is the background of intellectual property. Property means our mind directly goes to the tangible form of property and we say, I am having car, gold, plot, flat, many more things, so I'm rich enough. But there is a another kind of intellectual property called as intangible form of property which cannot be measured. That's an intellectual property, wherein we are having industrial property and copyright. Industrial property includes patents, designs, trademark, and geographical indications. Let us see how we can define the intellectual property. Intellectual property means intangible creations of whom? Human intellect having commercial value, asset like any other form of property. For example, if you're having many more flats in the Belgaum or plots, you can sell it or get the money out of that. Or if you rent it out, you can get the money out of that. Same way, if you are developing any kind of technology, you can sell it, license it, and you can get the royalty out of that. If you are developing new design, you can sell it, license it. If you are developing books, sell it, license it. So you can also earn from that. Therefore, intellectual property is also an asset like any other form of property. There are different intellectual property rights. IP is called as an exclusive right. For example, if you are developing new design for computer, we already know Dell, many computers, Vivo and all. If you are developing new design for that, you can license to that IBM company. If they are interested, you can go earn money out of that. But who can? Only the applicant, only you on whose name that design is registered. You can sell the patent on whose name registered, not your brother, sister, nor your teacher or college. On whose name it is there, they can have the right. Therefore, it's called exclusive right, or we can say negative right, because other persons are not authorized to have right to sell it or license it. Again, IP is territorial right. Once you are developing technology or your mark and filing in India, it's valid only in the country of India. If you want to establish your right in other countries like USA, Japan, Germany, China, or you want to stop them from using your technology, then you are supposed to file your application in those countries also. How we can file? By two ways. One is called conventional route, that is section 135 of the Patent Act. Another is PCT, that is called Patent Cooperation Treaty. Again, IP is also called as licensable right. If I am developing today Omicron composition vaccine, then I can license to Biocon of Bangalore or Bharat Biotech of Hyderabad for more production, and I can get the royalty out of that. Therefore, any IP, or we can say IP is an licensable right. Now, what is patent now? How we can define it? Exclusive, monopoly privilege, or right granted by the government to the patentee for how many years? 20 years from the date of filing, or priority for what? Commercial gain, not to keep as a record of the file record. In consideration of the full disclosure of his invention as a territorial right not order. Many professors, many students, many researchers comes to us, they say, I have developed a new process for production of beverages. Two steps are very important. I don't want to disclose with you because you may copy. My dear participants, you can keep in mind that once you are filing in the government of India or anyways, we are counting the time from seconds to minutes and hours, and you are the first filing or first claiming, no one will copy. Again, you have to disclose everything you say you don't want to disclose. But as per section 10.4 of the Patent Act, you have to disclose everything clearly with the examples. Why? Because after 20 years, if anyone want to practice your invention, then plainly they can practice. If you are keeping some hindrance, if you are not explaining clearly, then the person who want to carry out the or repeat the same invention will not. Therefore, you are supposed to file everything clearly. Then only you are getting the right for 20 years from the government of India. Still, many are in confusion. What is discovery and invention? Discovery means finding or exploring something which is already exist in the nature, or discovery as such no technical effect. For example, we know cement industry, jute industry, or any pharmaceutical industry. They are having a lot of effluents with very bad smelling, and they are having very microorganisms. If I am being a microbiologist or biotechnologist or biochemist, isolating that microorganism by using some methods. The method at what I am employing or using to isolate may be new. Then I can file the patent for isolation of microorganism, but not the microbe as such, because I am discovering it. It is present in the nature, just I am isolating it. But if I am modifying that microorganism by using genetic engineering technology, then again it is patentable because genetically modified microorganisms like oil eating bacteria. So if you are carrying out research, you should know, are we doing inventions or discovery? If invention, we have to file the patent for that. Now, if when we can say that your subject matter or your project or research is qualifying the definition of invention. Invention means new product or process. Many people ask us, sir, idea patentable? Yes, your idea is patentable, but not idea as such. Idea should come in the form of product or process. Today I am getting idea that I should develop an biodiesel because petrol and diesel may not be available for the next generation. So that's my idea. But idea as is not patentable. Really, if you are developing new process, or really if you are bringing product as an biodiesel, then that is patentable. Because if you are thinking, I can get many ideas, but if I'm not coming, not bringing in the form of product or process, then it's not patentable. Today, I'm getting idea that I should bring dandruff curing shampoo in the market because Clinic Plus is also there. Dove shampoo is there. Vatic is there. Even though I am not able to cure dandruff within a week. Therefore, I am being working on the medicinal chemistry. I want to bring new formulation of shampoo which can cure your dandruffs. Then I have to bring all the results how I am curing. What is the ingredient of that shampoo? I have to all detail means that's an idea came, but you are bringing in the form of reality. Then it is patentable. So invention means product or process. Process of preparation of shampoo. Product how shampoo containing swine emulsion, that is a product. Device which can produce beverages from grapes. Device is a machine, that is a product. For paracetamol medicine is a product, but process of preparation of paracetamol. So idea should be in the form of product or process. Again, it should be useful. Again, it should be new and non-obvious, not public knowledge before the filing date. Even for the paper publication, what we do, we check whether the technology, what is available with me, is in any other journal, national interest published or not. If not published, then only we go for the publication. Same way, you have to check whether you are fulfilling the requirement of invention or not. If it is invention, definitely you can apply for the patent and you can protect your technology. I've taken simple example sharpener. We know earlier we used to means our parents we can see, because now we came, then we are having sharpeners. Before that they used to take blade to sharpen the pencil, but now they got device. Why? Somebody has invented first time, therefore it's an device. And keep in mind that patent is an techno legal document, so technology we have to describe in the way of legal plus technical knowledge. Again, in the general knowledge, we have studied who has invented electric bulb, who has invented telephone, who has invented aeroplane. All we know, first time those who invent, they got patent for that. That is Thomas Alva Edison for electric bulb, A.G. Bell for telephone. So, can anyone tell me the technology telephone with us in the year 1876, but our scientist of electronic and telecommunication gone up to the mobile phone? Why? What was the necessary for that? Why they gone up to that research level to bring the mobile phone? Can anyone? As we are connected virtually, that we can make an interactive session by adding your points by thinking innovative way. Anyone? Professors, students, if you want to add something, because this telephone has two disadvantages. To overcome that disadvantage, we are gone up to the mobile phone. One, I cannot change this telephone from my cabin to my principal's cabin because it is connected at a particular point. Again, if I want to dial my parents or brother or sister, 10 times I have to dial. Very tedious, hectic. To overcome that, scientists of electronic and telecommunication did research. They came with the table phone. Directly I can dial, but again, one disadvantage is I cannot change from my cabin to my principal's cabin. To overcome that, they got cordless phone, which are long, and we can take in the hall, kitchen, and drawing room. Somebody speaking, please mute. Dear coordinator, you are authorized to mute them. Then we got cordless phone, where we can take in the hall, kitchen, and drawing room. But we cannot take in the meeting, nor in the jab, nor in the car. To overcome that, we got the mobile phone in India around 2000. In the year 2000. In that simple Nokia mobile of silver color is more than 5,000 rupees. Again, only incoming and outgoing were there. No video calling facility. But now we got video calling facility. Now you are sitting at Belgaum. I am here at Nagpur, but we are speaking to each other. What is this? Improvement of technology. So I want to convey one message that to get it patent, something new is not required. If you are solving some problems, if you are doing some improvement, you can get patent for that. Again, Bluetooth, new invention, nano car, Jaffer's vaccine. These are the inventions which we are having. The smart cards, drones are the examples of invention. This fellow Ranganathan developed a device being an uneducated fellow because he was working in the coconut field and he is very tiresome to climb the tree. So by thinking in the middle of age 50, he got solution to that problem. 4 lock pin system. If you press on both sides, directly can climb the tree. Means anything, any problem, if you give solution, that's an technology. Now, let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. I have taken Bajaj iron box as an example. If you check, your house may have different kind of iron box. The design is different. I'm using Dell computer. You might having some other computer. The design is different. I'm having Samsung mobile. You might having Apple mobile. The design is different. I'm using Crompton fan. You might having Ketan fan or Bajaj fan. I'm having Samsung AC. You might having Daikin AC. You can check the design is different. My wallet is of this design. You might having some other kind of wallet design. Wallet design. I'm having this kind of jug to drink the water. You might having some other kind of design. This is a new design. Milton has got registered this design. So something which looks beautiful, that's an design. This is an flush design. And you might be having some other kind of flush in your house. Brush designs are of different kinds. Car design. Even you can check the handle design. Something which is different from others. Mere functional or technical feature of the article are not considered design. How it looks, that's an design. If it is beautiful, that's an design. Term is 10 years. If you are registering in the government of India, you can extend for 5 years. Total 15 years terms you can enjoy, means you can license it, sell it. Within that you can get the money out of that. Again, I'll show you different kind of design. Set of articles: sofa set, cup set, spoon set, chair set. Different designs are available, which looks beautiful. That's an design. Sanitizing machine, new design, already got registration. Many products in different sections like pharma, ampoules. This ampoule is different from this ampoule. This medicine design is different from this. This syringe is different from this. So something which is different, that's in design. This again, ampoules are different from these ampoules. So something which looks beautiful are designs. If you go to textile and jewelry, there are different designs you can see. Curtains, bedsheet, jewelry designs are different. I am using Timex watch. You might have having Titan, some other company watch. You check carefully. the design is different. And you might having rings are of different design, earrings, bangles, any kind of jewelry are of different. Something first time who invents or designs, they can register and that company can take license from you to come up with the same design in the market. So they have to pay the royalty for you. Daily consumer products, I can show you this bag is of one official bag. You might have some other kind of bag. This iron box is different from this iron box. I shown you my wallet is different from this wallet. This comb is different from my comb. My comb is round comb. So this and brush designs, bottle you can check, aquaguards, aquafine, sunrich, rail water, Bisleri water. All the designs are different if you check carefully. Even shape, configuration, surface pattern of the bottle is also protectable under in design act. This surface pattern is different from this is different from this and this. So something which looks beautiful different from each other is an design. School bus design is something like this. If it is not in the public, new design. Bats are common, but bat with this design is not there. Pen design, sharpener, pencil design. We know many biscuits like Parle-G, Good Day, Monaco, Bon Bon, but this design is different, which can attract to the small children like Tom and Jerry face. So design is different. This is an example of technology. The Garrett Morgan, while passing on the road, he saw a terrible accident between car and horse carriage. He never gone as we usually go. He thought, why the accident has happened? How can I prevent this in further? So by thinking, way of innovative thinking, he got solution to that problem as a signal system. So I can say inventions make our lives safer. So please think to give new designs, think to give new technology in the market which can benefit to all the public. Even different designs like pot designs, jewelry designs, cookies, this all the designs are different from each other. So you can go for the registration. These are the different kind of dress designs. This design was developed by one of the students, that is Vikram Dhirabhai Panchal of National Institute of Ahmedabad. Why he might have got idea to develop such kind of design? Why can't you and me? Every science students or art students or law students, they are supposed to file their project in the final year. Science fellow do technical projects, arts fellow do written up copyright new type of books. So depend upon his old field. So design fellow has to do something new design. So he carried out the survey in the construction company. In that, he found that some of the people who work in that construction company having neurological disorders, back pain, disc pain. To overcome that, he given the idea of this design where it never touched the head. You can check gap between head and this device. So easily they can carry stones, sand, cement, or bricks on their head, and it never cause further neurological disorders, nor disc pain, nor back pain. So these are the example of new design, how he might have think innovatively. So if we are also thinking in this fashion, something to develop new, definitely we can solve one or two problems and you can apply for the patent designs on all, depend upon what type of invention you are doing. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, to distinguish from the goods of the others. Like use the authenticity goods like Reliance, Airtel, Coca-Cola, Coca-Cola, Good Day, Mazda, Pierce. Many other companies already got trademark which is registered. ICICI Bank, FedEx, HDFC, SBI advertises goods and services. This one. Protect the innocent public from buying the goods of second-rate quality. For example, if you have seen Adidas shoes, Puma shoes in the market, if you go to mall, it is more than 5,000 rupees. If you go in Mumbai roadside, like Bindi even in 200 rupees. Even Bangalore on roadside, if you go 200, because They change the spelling of that mark, but we never check carefully. Adidas, ADIDS. They put ADI, they put A only. We never check what exactly mark is registered. Therefore, we will be cheated in the market. Ponds powder. Spelling is PONDS. They put POU. We never check because color is same, outer look is same. We buy that. That's in secondary quality. So we should know what exactly mark is registered. That mark we should know. And this R insert is a registered trademark. TM means they have applied it to get permission from Government of India. Why? Once you are developing any mark for your startup or MSME or developing new company, then you are filing that mark name to the trademark registry in the Government of India. Then it's go for the examination. Examiner carry out the research. They file, put the objection to you. Then you have to reply for that. That is called first examiner reply. Any opposition may come after publication. Then you have to deal with the opposition proceedings. Then finally, if everything is okay, then you get the mark that is R with encircled, means registered trademark. TM means they have applied for the mark, but yet to get the permission because they have to complete all the procedure of examination, opposition, hearings. Then finally, if it is new, then it go for the granting the patent. Term is 10 year. You can extend for more than 10 years if it is in use, like Tata, Bata, HDFC Bank, ICICI banks. They are renewing every 10 years uses. Please don't talk. There are different trademarks including service mark, trade names, collective marks, certification marks, taglines, slogans, saves like Google.com, Adidas, Naukri.com. These are the uh, different kind of marks. Why to protect a trademark? Trademark is an optional. However, Russian has certain advantages. Russian is available. Any disturbance, please?
Nan- Nandan,
Please see any.
Nandan, sir, just a second, sir. Just intimate the technical person.
Okay. Yes. Why trademark is registration is important? Trademark registration is an optional, it's not compulsion. However, registration has certain advantages. Registration available at the national, regional, or international level, that is by Madrid Protocol, you can get protection. Initially, register for 10 years can be further renewed indefinitely 10 years each time and so on. In case of like Tata, Bata, how long they're in the market. In case of non-use, non-renewable or no policing, trademark rights are lost. The existing trademarks registration is governed by the Trademark Act 1999, the Trademark Rules 2017. For more information, please visit our website. Let us see another kind of intellectual property called as geographical indications. GI means place names used to identify source of origin. Source of origin. Yes, GI means place names used to identify source of origin, quality, reputation, or other characteristic products like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges, Kolar gold mines, Terry Tyler of Solapur, Mysore silk sari. Many are the GIs we got. You can check Makrana marble of Rajasthan, Ratlami Sev, Kanchipuram silk sari, Katputli of Rajasthan, Bagpur of Madhya Pradesh, Cherali printings. Many have got GI. Magai pan, Devanelli Pamelo, Kapimadi mango, Kashmiri saffron, Sahilicha Bihar, Coorg oranges, Tirupati laddu, Rasgulla, Bengal and Odia. Many have got GI nowadays. In case of GI, single person cannot file the application. In patent,
Voice lost. Voice, please.
Just a second, sir. Just a second.
Ma'am, there is no audible.
Yeah. Sir, Bharat sir, kindly unmute yourself. Bharat sir.
Muted me, I don't know. Okay, no problem. Are you able to see slides?
Yes, sir. Yes.
Okay. So let us see another kind of intellectual property called copyrights. Copyright is a bundle of rights. Provides holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60 years. Even in software being a computer program, it is not patentable in India. Software with the hardware is patentable like computer, ATM machine, mobile are patentable, but not software as such. They comes under the copyright. The term is life of the author plus 60 years. You might have heard many singers sung the song. They are no more, but still they are getting the royalty for that. Many authors written the book. They are no more, but still they are getting the royalty for that. As you know better than me, as literary works, we can get protection. Artistic work, we can get protection. Dramatic, musical, sound recordings, even cinema. Many court cases are going in the, they are copied my dialogue of my movie. They copied my first main figure or main picture of my movie. They copied my lyrics. So all the court cases are going, that is infringement of the copyright still in the courts. Now, if you are developing any device or technology, how we can protect with the different intellectual property rights? For example, I have taken simple example so that any common man can understand. Sony TV was very famous in the year or in and around 2004 or in and around that period for clarity and sound, especially with the two hoopers on the top of this TV. If you remember, the remote control mechanism is technology. I am sitting on sofa set and operating the TV. It's a technology. So the technology got protection by Sony company by patent. And how it looks with the color combination, new design, beautiful, they got design protection. Named Sony in this fashion, they got trademark. And the instruction which are there in the box of TV got copyrighted. One single product we can protect with different IPR so that other company who involved in the manufacture of TV will never copy these things. Like, for example, Samsung company that also producing TV, that is Samsung TV, but they never copy the patent, design, trademark. If they copy, Sony company will sue them in the court and they claim the damages for that. Therefore, if you are developing any technology, protect it with different intellectual properties so that other person will not copy any one of these. Again, another kind of intellectual property called trade secret. It's an intellectual property never been disclosed nor published in any books or journals. It maintains secretly. Therefore, I've taken the example of Domino's Pizza to make you understand. Earlier, on the birthday parties in the college, or if you're getting good marks in the college or schools, we used to take parties and poha or something like this. But nowadays, people are students of the law or any college, they are ordering pizzas on simple birthday of their classmates, or if he's scoring high marks. So they know the taste better of the pizzas. So I am taking here three examples of the pizza. One, the pizza which is we are getting or ordering from Domino's Pizza. Another pizza if you're getting in common hotels, we are getting nowadays. Another pizza which is prepared in the home by our spouse, mother, or sister, or anyone else in the home. The taste of pizza, if you see carefully, being a scientist or being a person who is expert in the field, the taste of Domino's is something different from other pizzas that may be fluffy or something different. You can check after my lecture also. So the taste it is something different because of they're adding some trade secret in that ingredients which are not known to them. They're known to the people who work in the kitchen of that by non-disclosure agreement. Therefore, We don't know the formula of Coca-Cola. Till today, we don't know the formula of Mazda because they're not disclosing, they're maintaining as a trade secret. So if you're also having any trade secret, you can maintain that. Even the recipes you can check. Mumbai pav bhaji is different from your Belgaum pav bhaji or Bangalore pav bhaji. And Shahuji of Nagpur is something different from the other spices. So these are the different recipes, also trade secret we are having and they're maintaining. Even if you check different mobiles like Nokia, Samsung, Vivo, all got protection for the technology as and patents, design, trademark, so that they never copy each other technology. Like Samsung will never copy the technology of Nokia. Nokia will never copy the technology of Apple. If they are copying, they will sue in the court. Therefore, it must, if you are developing any technology, you can get protection in the government of India. This for the students. What is the usefulness of this IPR program? Why government is making to understand about the IPR to file more patent, perform a design, even for the students how it is beneficial. The students who are listening to me, if you are a science graduate, you can become a patent agent. Every year, our office calls for the examination of patent agent. Two papers, one is objective and the descriptive. If qualify, you will get a patent agent number from the government of India. You can file and you can work. If you are a common law graduate or commerce graduate, you can become a trademark agent or copyright agent. If you are having knowledge of IPR, you can work in the IPR policy, IPR cell of central government, state government, colleges, universities, companies, you can work. You can work in the NGOs who can become facilitator to inventor to the government of India. You can work the IPF firms in big cities. We are having different IPF firms like Bengaluru, Hyderabad, Mysore, even in Nagpur, Mumbai, Delhi. Many IPF firms are there. You can join there also. If you are a science, any branch, or MSc in chemistry, biotechnology, biochemistry, you can join the government office also. There is again depend upon the vacancy and advertisement. Now you came to know about the different intellectual property like patents, design, trademark, geographical indications. Now, how to file the patent application in India and who can file? Any person, natural, startup, MSME, anyone, there is no age bar limit. Anyone can file the patent application at any age. How we can file? By physically, you can go to the different jurisdiction. As you are from Karnataka, your jurisdiction is Chennai, you can file. Or sit in your own office home, you can file online also, as you are given the facility to file the online application. Your jurisdiction is Chennai because Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Union Territories of Pondicherry and Lakshadweep. Newly formed state Telangana is your jurisdiction. You can file these states in the Chennai also. Yes, ma'am. Hello. Any doubt? Hello.
No, sir. No,
My
sir. No, sir. Carry on.
okay.
Carry on, sir. No, sir.
Okay. Yeah, minimum documents required for patent filings are covering letter indicating the list of documents. Application form 1 indicating the name of the applicant, contact number, type of application in that column 9 has to be signed by the inventors who are helping to develop new device or technology in the market. If you are filing provisional or complete application, form 2 is required. Provisional means as soon as idea comes to your mind, you are filing the application. For example, today I got an idea that I should produce herbal medicine for Parkinson's disease. Then I can write on the paper, I can file that is called provisional. Complete means after completing all the research work with the claims if I'm filing, that is called complete application. That is on form 2. Form 3 is required if you are filing your application in foreign countries. Which country you are filing, name of the country, status and application number you have to produce in India. Form 5 is required to declaration of inventorship. In paper publication, we add our friend's name. You are the first author, then your lab mates or your friends are second, third authors. Same way, if you want to add your friend's name in patents, you can use the Form 5. That is declaration of inventorship. But in paper publication, first author is having more value. Here, everyone will have equal value. So please Think before adding. Otherwise, if you are developing any technology, once it get more value, you have to share your benefit to everyone. Request for examination is on Form 18. You have to make drawings, if any, sequence, all you have to mention in the applications. Fees for filing is 1,600 for natural person, 8,000 for the others. You can check the website. Detailed fees is given in that. This is an up to 30 page. More than that, 160 per page for individual, 800 for the others. For each claim more than 10, 320 for per claim. For company, it is 1,600. And for the teaching institution, you are the college, so 80% fee concession for all the teaching institution. Please keep in mind. This is the online filing fee structure. If you are filing hard copy, 10% in addition to above mentioned fees. If you are requesting for examination, 4,000 for the natural person, 20,000 for other than that. Form 9 is not compulsory, it's optional. If you want to publish request, then you can publish. For early publication, you can request. If you want to get patent early, you can file an expedite examination as per Rule 24B of the Patent Rule 2003 as amended. In that, Form 18A is required. Who is eligible to file a Form 18A? While filing PCT application, PCT means Patent Cooperation application, if you are choosing India as an international searching authority or international preliminary exam authority, these are the authorities wherein if you are filing your technology, they give you remark it is new or not. That is called international searching and international examination authority. Or if applicant is an startup, or as per 2019 rule, one of the applicant in your group is an ladies, or any government organization or institute can also request for expedite examination. Fees for Form 18 is 8,000 for individual, 60,000 for the others. This is the website wherein you can get all the forms. If you want to file patent application online, IP India online.go.in e-patent filing login, you should have digital signature or e-signature to file the patent application. If you want to file trademark application, you should have digital signature. If you want to file design application, you should have digital signature. If you want to file copyright application, there is no need of any kind of signature. Login, create your own ID and password as we are booking for trains and all, creating your own password ID. Fill the application, upload the document like book, drawings, whatever you are having, any software program, then pay the fees online. That is an application is completed. How we are granting the patent in the India? Once you are filing the application, we take it for the screening and classification, because there are different branches like biotechnology, microbiology, engineering, mechanical, electrical, electronics. So we should identify and classify it. We use international patent classification system. Why it is necessary? Because we are having auto allotment system. We cannot go to the we allot to the controller of mechanical, electrical, biotech. It is automated, so classification must. If you are requesting for early publication, we publish within week or a month, otherwise 18-month publication time. If you are requesting for examination within 48 months from the date of filing, it will go to the allotment to the examiner and control, like one of the examiner and control will be allotted for the particular case. Examiner will examine the case, put the report to the control. Control again add, modify, delete the objection, prepare the final report and send to the applicant or applicant agent. That is called first examination report. Then you have to reply within 6 months. If you are unable to reply, you can take the extension of 3 months. Within 9 months, by hook or crook, you have to file the reply. If you are not filing, it will be refused or abandoned. If the reply is okay, it will be granted. Once it's granted, you see here, once it published, anyone can oppose. That is called pre-grant opposition. But after the grant, it published within 1 year, only interested person can file the opposition. Here, any person, but here, only interested. Now, who is the person interested? For example, Biocon of Bengaluru is preparing some herbal medicine. Then Bharat Biotech Hyderabad, Glenmark of Mumbai, Serum Institute of Pune can oppose, because they are involved in the manufacture of pharmaceutical products only. They can oppose. They are called as person interested. Inside the office, we constitute an opposition board. They give the recommendation on the opposition. Then applicant will reply all the opponent's ground. Again, opponents will reply to the applicant's reply. Then applicant or opponent request for the hearing, we take an court hearing, like court hearing, we call them across the table, we discuss each ground of the opponent. If applicant is able to overcome all the grounds of opponent, then only it is granted, otherwise it will be rejected. If you are granting or rejecting, we give the speaking order so that you can appeal in the higher courts if you are not happy with our orders. If granted, same day we issue the certificate of grant. Now, how to file the design application if you are developing new kind of any designs. If you're patent registration any advocate, you can go through the advocate, or alone you can file. Natural person fees is 1,000 rupees, small entity 1,000, startup 1,000. Other than that means companies 4,000 rupees. Application fill form 1 and fees, name of the applicant, legal status, address, class of the design, which class it comes, we have to know. Name of the article, we have to mention like traveling budget, like suitcase, briefcase, private data if any, registration if any. Two sets of the representative you have to make, power of attorney if you are going through the agent, private document if you are having, assignment if you are having, form 24 if you are startup or MSME you have to file. There are 32 classes of the designs. In that 237 are subclasses. We are following Locarno classification system version 13 for the classifying the designs like footwear, clothing, articles of traveling. All the different designs are there. You can check. You can check in the Google or even the design atlas. There are different classifications. These are the how to write the applications for the design. I'm taking the example of teapot. I'm claiming new design of my teapot. Then name of the applicant, so and so. Total number of seats are 5, 1 of 5, 2 of 5. You have to mention on each seat. You have to give perspective, side view, front view, all the views you have to cover, and you have to say it should be clear view so that because it should look beautiful. Ultimately, how it's made is not important. Design means beautiful. So I'm claiming here novelty resides in the shape and confines of teapot, means how it looks. No technical matter how it resides. Name of the applicant. This is a way of writing the design application and filing. These are the bad quality of the designs. What is the role of patent system? Increasement or improvement of technology. X-ray pehle tha, we got CT scan machine. Earlier telephone tha, now we got mobile phone. We are doing always improvement. Providing reward as an exclusive right for display. For something doing new, government is giving you right. Making profit or earning by putting the invention to practice. If you are doing something new, please bring in the market, sell it, market it, then you can get the royalty for that. Transferring into public property after 20 years, or that is once patent is seized, means you have got the patent, but if you are not the paid the renewal fee up to 20 years, it will be seized. Now what to do? Now you came to know about all about the intellectual property, like including patent, design, trademark, copyright, trade secrets. Now don't keep quiet. Share the benefit of patent system or IPR in school, colleges, universities, everywhere where you get the opportunity, even in the public domain. Utilize the resource through organized R&D activities. Capture the global market judicially. Earn the profit through the protected market. Thank you. You can ask any questions now. Session is open for the discussion.
Yes, participants now. The topic is open for interaction. If you have any queries, kindly put them here so that Dr. Bharat will be pleased to respond and answer them.
Even students can also ask any doubts.
You can unmute and ask. Yes.
Students, do you have any questions? Participants, do you have any question?
No, ma'am.
There's one question I think here.
Yes.
How long do it is chat box from Pavitra Patil? How long do the legal proceedings take for IPR disputes?
Sir, see, up to the grant is in our hand. IPR disputes are in the court, so you know court proceeding how much time they take. There is no exact date for the court proceedings. All the proceedings of disputes will be in the court only, not in the Indian
Okay.
Patent Office.
So they are subject to the normal procedure of the court. Okay.
Yes, court
Sir,
as usual.
Sir, is there any limitation to file objections against any trademark violation like that?
Yes,
Like
sir.
we have under
Yes,
Limitation Act.
yes, time period is there. Within that time, you are supposed to file, sir. You have to oppose within 6 months like that.
Okay. Yes.
Sir, I have one question.
Yes, sir.
Sir, inventions relating to agriculture, can they be patented in India?
Invention related to agriculture is only agricultural equipments are patented, like John Deere tractor, which are making for plowing, sowing the seeds, but not the method as such. Method of making seed or method of fragmentation, pollinations are not patentable. Our plant as is also not patentable. But the agricultural equipments, what you are making in the field of agriculture, that all equipments are patentable in India, and agriculture products are patentable under Farmers' Right Act PBVR 2002. That is different. Any other question?
Yes, sir. Thank you, sir.
Please don't forget to fill the link. Circulate the link in the chat box so that everyone should get the certificate.
Yes, sir. We have done it, sir. We have
feedback link is shared now.
Sir, yeah, he's sharing, sir. Nandan is sharing, sir, within 2 minutes.
Yeah, feedback link is shared now. Yes.
It's shared. It's shared now. Vinay, are you there? Vinay?
Yes, ma'am.
Yeah. Sir, I think there are no more questions now.
Okay, ma'am, we can confirm.
Okay, Vinay.
It gives me immense pleasure to address the vote of thanks for today's program. On behalf of B.V.Bellad Law College, Principal Sir, staff, and all the students, I thank Dr. Bharat M. Suryavamshi Sir for enlightening the students on various aspects of IPR law and for giving your valuable time. Thank you, sir. And also, I would like to thank Dr. Belagavi Sir for organizing this awareness program. And also, I would like to thank Mr. Nandan Patil Sir for the smooth conduct of this program. Thank you, everyone. Thank you. Good day.
Kindly, the link will the meeting link will be open for another 5 minutes. Before we leave the meeting, please fill the Google form, all the participants, because after 5 minutes we'll be closing this event. Okay.
You can circulate in the classroom. Those who are sitting in the classroom and listening.
Yes, sir. That we have shared it in our students group, sir. We have a WhatsApp group there. We have shared. Now, any outside members are not. So outside the academicians are who are joined from the various colleges. Sir.
Yeah, if even various colleges can also conduct this and free program, which is gone by the central government of India.
Yes,
you have
sir,
to request on our email ID, or you can take my number from the sir and you can call me or you can mail me. Definitely, we will conduct the program throughout our Karnataka or throughout India so that everyone will get awareness about the IPR.
Yes,
yeah, China and US are doing filing more and more patents and design. Even our India should go because everyone is having keen observation, but there is no known that how to file and all. Thank you.
Sure. And I'm thankful to you because recently I had been to a science college where I was informing the science graduates that what will be the career prospects for them when they take up law. Because if they become a law graduate with the with the life sciences graduation, they can become patent attorney or like that. I was telling about them.
BSc, LLB are very less people are there.
Yes, sir. Yes. I know.
The law should be very much important. Even now, court has made if you want to do the infringement case of patent, there should be science graduation for the lawyer.
Even that,
lawyer without science background, he cannot practice the infringement case of the patent also.
Yes.
So special courts are now designed to work on IPR only. So lawyers are having a lot of scope in the IPR as compared to the others. I can say directly.
Yes. Sure, sir.
Thank you, sir. Thank you so much for
Thank you very much.
all.
Thank
Anytime
you.
you can have any time
Sure,
discussion.
sir. And we look forward, if possible, if we can have one online workshop here like that, if you could travel, so that we can take care of all the logistics. That because Belagavi is a very big city where you
Yes,
have
yes.
all the facilities.
I
We have,
visited many times to Belgaum.
yeah.
And my sister's son is studying MBBS in the Belgaum.
Oh, great.
Belgaum is
That's
he's
good.
in the
That's
final
good.
year.
Yes,
Before
sir.
that also I visited many times.
Yes, sir. We look forward for your association.
Yeah, even Kotali Kupanwadi of Belgaum, Choice and Belgaum College.
Yes,
When
yes,
I
yes.
was I came nowadays school sports meet. I used to visit all the district of
Great.
because I studied my basic education from Navodaya Vidyalaya, so I roam around the schools, even Belgaum especially. I liked especially food there; it was very tasty.
Yeah.
Thank you,
food
sir.
is right.
Tasty, yeah. I was in Kothali Kupanadi for many days for the sports.
Okay.
Thank you, sir. Thank you, Baba.
Sir, thank you, sir. Bharat, sir. Thank you, sir.
Yeah, thank you.
It was very informative, sir. Thank you. Sir.
Thank you, ma'am. Thank you. Most welcome.
Participants, please fill the feedback form, because with that link only, after filling the feedback form only, you'll be getting the certificates.